Hey, ladies and gentlemen, we are going to finish off the constitutional amendments dealing with criminal law. And so, just as a refresher, we're going to just back up and go through the two that we've done so far, just to make sure everybody's caught up and on the same page. We started last week with the Fourth Amendment, dealing with searches and seizures, the need for a warrant. To get a warrant, there's a requirement of probable cause. Here is the definition of probable cause. And in order for law enforcement to get a warrant, they have to swear under oath to the judge that everything they're telling them is true to the best of their knowledge. And the warrant is going to describe who is being searched, what are they looking for, where is the search going to happen, is there anything that they're looking to take into custody as a seizure. And then we went into the Fifth Amendment, and we all got through the Fifth Amendment last week. We talked about due process being the government's responsibility to make sure, let me just get my highlighter here, to make sure that you are not deprived of your life, your liberty, your freedoms, or your property without due process. Due process is fair and equal treatment under the law. We also talked about last week the ability to protect yourself from being a witness against yourself. That's the I plead the fifth. I don't have to testify against myself. We also talked about double jeopardy, the protection that you do not have to be charged or they can't try you for the same crime twice. And then we finished off last week going through what is a grand jury. And we said a grand jury is not a trial. There is no verdict. There is no judge. The defense is not present. Therefore, it's hard for the defense to give any objections. We said a grand jury is made up of 23 jurors. It is all the prosecution. The prosecution runs the show. And what they're asking the jurors is, as a prosecutor, do I have enough evidence to actually charge this person with a crime? If the grand jury says yes, they will return what is called a true bill of indictment. That means they're giving approval of the charges. We also talked last week about how the federal government requires this for all capital crimes. There's that capital crimes right in the amendment. And how Minnesota requires a grand jury for all first-degree murder cases. So with that, we're just going to keep going where we are. And that's gone one too far. And so our next one that we are covering is the Sixth Amendment. So if we go back and we look how these go in order again, we need the evidence. Once the evidence is in possession of law enforcement and the prosecution, then a formal accusation can be made of an individual. Once that accusation is made, then there is the process of a courtroom. If there is no plea agreement and the prosecutor and the defense cannot come to an agreement, then they are to go into a courtroom for a trial. If the person is found guilty, then it will go into the sentencing phase. And so I just want to make sure that we're all familiar with that process. So going into the Sixth Amendment, there's a lot in the Sixth Amendment. So we'll get started first. Let me go back to my highlighter. The first thing is that a person who is accused of a crime shall have a speedy and public trial. So when we're talking here, we're only talking about the criminal law, excuse me. So the first thing we want to put down here, and I've got to get a smaller font because that's way too big, is the right to a speedy and public trial. Okay, so when we're talking speedy, we're not actually saying that somebody gets charged and then the next week their trial starts. This is really protecting an individual from being arrested and held in prison for years before they're even accused and years before they're even put on trial. This is saying to the government, you've got to do this with some deliberate speed rather than just holding somebody for an indefinite amount of time. So even though it doesn't give us a specific as to what speedy means, we know what not being speedy is. Public. Now, there are times where the public may be allowed to be in the courtroom, and then there's times where the courtroom is closed off to people who are not connected to the trial for safety reasons. But this protects us from the government taking us behind closed doors and deciding our verdict without giving us a chance to the public being able to know that the system is up and up, that they're not abusing people by making decisions behind closed doors. The second thing this amendment talks about is what is called an impartial jury. Now, that can be a little confusing to people as well. Impartial is really talking about being unbiased. Now, to be honest with you, being unbiased isn't realistic because we all have biases for many things in our lives. What this is basically saying is that anyone who is a juror in a criminal case is going to have the ability, must have the ability to examine the facts and apply the law without having made a pre-decision. Okay, so we have to be able to come in and hear the case and look at what are the facts, not judgment. You can't come in with a prejudgment and say, well, I don't care what the facts say. I think this person's guilty. You can't come in. You have to look at just the facts and apply it to the law. Okay, you may not like the person, you may not like the attorney, but you still have to be able to come in and make a decision based on facts and what the law is saying. Third, it says, if we're going back and looking at the wording of the law, so here's the impartial jury, and we are going to look at today an interview that was done with some of the members of the Derek Chauvin jury that spoke in an exclusive interview with a reporter from CNN about their experience. And we'll talk about that here in a second. The third thing that is in the Sixth Amendment is that the person is going to be tried where the crime was committed. Okay, so when we look at that, and I'll get back into this, let me go back here, that they are going to be tried where the crime was committed. Okay, so it prevents the government from taking somebody from Arizona having committed a crime and bringing them to New York for a trial. They want the jury to be a part of the community where the crime was committed. Okay, just to protect us. We want to be. It really is setting up the system to be tried by a jury of your peers. So people who are familiar with your community, people who are from that area where the crime took place. All right. The next thing we see in this amendment is that you have the right to be informed, oops, that didn't go so well, of the accusation. So what that means, and that'll be our number 4, is that you have to know your charges. They can't all of a sudden you're taken into custody and you're brought in front of a jury with a judge, and you don't even know why you're there. So there is a legal procedure, and that is called an arraignment, where the judge will formally read your charges. Okay? So it's not a surprise at your trial to find out that you've been charged with a crime you didn't even know was even possible. Okay? And again, remember when I say your, I'm not implying anything to you. All right. Number 5, and I may need to slow down a little bit, and I kind of get ahead of myself. Number 5 is the ability to confront witnesses against you. Now, that one is sometimes misunderstood. So 5 is, and I'll just put it as they confront witnesses against you. So this is essentially saying that you have the right to confront any witnesses, specifically on the side of the prosecution, that are going to testify against you. Now, when they say that you have the ability to confront them, that doesn't literally mean you get to talk to them, you get to ask them questions. What it really means is that you have the right to be present. You have the right to be present during the prosecutor's and I spelled that wrong, my apologies. The prosecutor's boy, I'm struggling here, portion of the evidence. So it's not a surprise to you that down the road you find out that during your trial they had somebody testify against you and you've never met the person, or you didn't know the person, or you didn't have a chance to hear them make accusations against you. So that is a really critical part. Sometimes we don't think about that, but if I'm on trial and somebody's going to testify against me, I want to be able to see that person. Okay, doesn't mean I'm going to intimidate, doesn't mean I'm going to try to talk them out of it. It just means that I get to hear what they're saying about me. In addition to that, the accused, the defendant, has the right to have witnesses on their behalf. So I have the ability, if I'm on trial, to have witnesses called on my behalf, somebody who was with me when the incident took place that can testify that there's no way I could have committed that crime because I was with them. Okay. It prevents the prosecution and the trial from being one-sided. Yes, I can't type today. Prevents trial from being one-sided. Okay. This is what we call cross-examination. Okay, so if the prosecution brings in a witness, the defense can cross-examine them. And then once the prosecution has given all of its evidence and had all of its witnesses, then the defendant has a chance to bring forth their evidence and their witnesses as well. And then the last one is a big one. We'll talk more about this in class in the next section after we get through these amendments. But the big part that a lot of people think they understand, but maybe not necessarily in its entirety, is the ability to have counsel. The right to have counsel. Okay, this is an attorney. This is a lawyer. This is legal representation. Okay. um, so that you're not put on trial without any skills or ability to move your way through the process without knowing what's happening. So that is a critical part of one's rights. So when we look at this, this is an amendment I'm not willing to give up by any means. This protects me if I am on trial. Okay. These are 7 things that I'm not giving up. Okay. I don't want the government to be able to hold me indefinitely. I don't want them to make a decision behind closed doors. I want people to make a decision of whether or not I'm guilty or not, rather than a judge single-handedly behind closed doors making that decision. I want to know what crime I committed. I should know that before I go on trial. I'm sorry, they're backwards. I should be able to have my trial in a vicinity where I committed the crime. I should be able to see who's testifying against me. I should be able to have my own witnesses and my own side of the situation, and I should have the right to counsel. Okay, so what we're going to do now is we're going to watch this video, and I want you to hear really there's arguments out there that these jurors in this trial had already made up their mind prior to this decision. And I think it's really interesting to listen to them talk about, did they watch the video? Did they take notes? Did they visit with each other before they went to deliberate whether or not he was guilty? Was there a process of was there bullying? Did they get in that deliberation room, the 12 of them, and somebody took over and said, this is how the decision's going to be made? I really want you to listen to what they have to say and how they came to conclude the verdict that they did. So we'll watch that next.